one of the scariest moments in any marketer's career, receiving a CID. That's a Civil Investigative Demand from the FTC. It's not a lawsuit yet.
Civil Investigative Demand, it is effectively a subpoena. It's issued by the FTC. You get it in the mail. That requires companies, whoever gets issued one, to provide.
The reason you get one is because they believe that you've done something that is against FTC compliance. So I have 14 days to take action. What is the first thing I need to do when I get one?
Don't panic. Well, there's one more step.
Picture this. One morning, you open your inbox and find a letter from the FTC demanding all your marketing records. What now? On today's episode, we're tackling one of the scariest moments in any marketer's career, receiving a CID. That's a Civil Investigative Demand from the FTC. It's not a lawsuit yet, but it is the FTC's way of letting you know that you're under a microscope. Ryan and I will be breaking down what it is, what it means, and most importantly, what to do if it lands in your inbox. Hi, I'm Emma Rainville, and welcome to another episode of Marketing on Trial, where me and my co-host, Ryan Poteet, break down some of the most interesting parts of legal and direct response and the e-commerce world. Ryan?
Emma?
Hello.
Good to see you.
Good to see you. So today we're talking about CIDs, Civil Investigative Demands. And this is so interesting to me for many reasons. Can you break down what a CID is first, and then what it means if you get one, or why you might get one?
So Civil Investigative Demand is it's a subpoena, basically, that requires companies, whoever gets issued one, to provide documents, information. It's the precursor to a lawsuit, like you mentioned, but it is effectively a subpoena. It's issued by the FTC. You get it in the mail. It's going to list out a bunch of questions. They're called interrogatories or specifications that you'll have to provide a written response to. There's going to be document requests. And then perhaps investigational hearings after that, where they're actually calling basically a deposition of people who have relevant information. So, in a nutshell, it's a subpoena. It's got a lot of components to it. There are deadlines. It requires you to move pretty much heaven and earth to get a lot of information together in a short period of time.
Okay, so let's talk about that. The reason you get one is because they believe that you've done something that is against FTC compliance, yes?
Perhaps.
Okay, or?
So the FTC, when they start an investigation, they can issue CIDs to a ton of people. It can be basically what I would call the target in the investigation. And if you look at the CID, it'll actually have like the nature and scope of the investigation. They'll tell you what they're looking at. Now, service providers, for instance, so say you're running a marketing, like you're running a brand. You are running some ads that get, exceed your claim substantiation, right?
Okay.
The FTC can issue CIDs to service providers, your advertising agencies, merchant processors, pretty much everybody in kind of the, your ambit to try to get information about what you're doing. So anybody can get one, but it also just kind of depends on whether or not you're the target of it or if they're just looking to get information from you.
Okay, so you generally have just 14 days to respond, right?
So you have 14 days to meet and confer with counsel.
So let's talk about that. So I have 14 days to take action. What is the first thing I need to do when I get one?
Don't panic.
Okay.
Don't panic. Don't panic.
I'm panicking thinking about this.
Oh, well, they're not fun. So when I say don't panic, this is not a demand letter from a plaintiff's law firm, with some kind of, BS consumer protection complaint, right? This is something that you actually need. There are deadlines and you actually need to respond quickly. So you've got 14 days, like it'll say what the response date is, but there will be 14 days to meet and confer with counsel. So what does that mean? You're going to talk to your attorney. You need to get an attorney involved. You should not be doing this yourself. You are going to meet and confer with opposing counsel. You're going to talk about the scope of their investigation. What are they looking for? How can we narrow some of these requests to make them easier to respond to? Some investigations are more expansive. The FTC may not know exactly what they're looking for. So some of the interrogatories or the document requests, they're just like asking for everything, which could be tough and incredibly expensive. So that first meet and confer, it's going to be in meeting with counsel, introducing yourself, and trying to narrow some of these scopes.
Okay.
If that fails, the next option, within 20 days of receiving it, you need to file a motion to quash. This is rarely done. The FTC is the one that's ruling on the motion to quash. It's not a great, unless there's a compelling reason to do it, you don't want to go down that road.
Okay.
It starts off a very adversarial process when the goal is to work with the FTC to see if you can work together in a collaborative a way to get the FTC what they need and hopefully move the investigation towards some sort of resolution.
Okay. So I'm just going to repeat back. So we don't want to delete anything. We don't want to delay anything, and we don't want to dodge anything. So in direct response, just to back up for a second, in direct response e-commerce, a lot of us have been programmed to when we get these, I just want to be very, very clear. I want to be very clear for a moment. A lot of us are programmed, like you get these copyright or these canned spam emails and letters in, and you ignore them because you're looking for people who will respond to get money off of. This is not that.
Definitely not. Definitely not. So you need to get in touch with the FTC. You need to make sure.
But you need to have an attorney get in touch with the FTC.
You do not need to be doing that.
Right.
You also need to distribute a legal hold. You need to stop deleting everything. Like business can continue depending on what you're doing, but you need to make sure you don't delete anything.
And a lot of us delete things automatically. So like my customer service calls, for example, I delete those within 5 days. This is not to say, though, there are certain elements to what you have that you protect, like when someone gives a credit card over the phone. That's not what we're talking about here. You beat this.
No,
we're talking about
data
standard
preservation.
Right.
So if you have a document retention policy, that needs to stop.
Right.
Like you need to start preserving everything.
Right.
And where this gets difficult is everybody uses Google Drive or some sort of platform
Box,
where things are constantly
Dropbox,
changing.
right.
You got to save all of that stuff.
Right.
And so that, you are going to need to find somebody who's going to be kind of your point person on getting all the documents and all the information together, but also identifying people who have relevant information. So whether it's in Slack or it's in Google Drive, are people using their own personal drives? You need to figure out where those documents are located, make sure that people are saving it.
Let's discuss that for just one moment, because operationally speaking, the amount of times that I've gone into companies and this contractor, this employee, this vendor, this service provider has your documentation in their drive, this can be incredibly challenging. And we worked on a case a couple of years ago. I don't know if you remember all of the SO for, I believe it was, you know how if the FTC, this is for FDA, if the FDA, if you have 5 levels of criteria on a complaint, you have to report yourself. But one of the contractors had it all in their Google Drive.
That's on you. You need to send out a notice. And kind of the fine line is a civil investigative demand. We kind of didn't talk about this before. It's private at this point. It's not a matter of public record. And so businesses don't want this to be public. I mean, especially if you're a brand or, any kind of business, you don't want anyone knowing that you are, under investigation, because immediately someone thinks that you did something wrong. There are plenty of reasons why you get a civil investigative demand. You might not have done anything that would result in any sort of liability, but for right now it's confidential, and so you want to walk that fine line of you got to tell third parties about the documents and information that they have so they preserve it. So you need to figure out who they are, but you also want to be kind of careful about who you tell, so it doesn't become a PR nightmare.
Right. Okay. So
hey everyone. Interrupting this podcast to remind everybody to like and subscribe our podcast and to sign up for the Visionary Vault at
www.specialopspodcast.com for a whole bunch of freebies. Step 1, notify or get a legal team if you get a CID immediately. Preserve all documentation and data.
Correct.
Do not respond directly without counsel is what I heard from you. Now I've got all that together. If they're doing this, it's because they're investigating me. My goal, your goal as my attorney, should be to get this squashed before it turns into a lawsuit or a fine or whatever, right?
Correct.
So what do I do now? So I got the attorney. I preserved all of my information, all my data. You've responded. Now what do I do to try and make this go away?
Well, there's one more step.
Okay.
I mean, so you get counsel involved. You've met with the FTC. You talked about some of the requests, how you can narrow them. At that point, all the work begins.
Okay, so, that's when it starts.
Yeah, that's when it starts.
Jeez.
Yeah, no, that's when it starts. You need to have one person who's going to be a point of contact, who's going to work with your legal team. I remember working with one client where I think it was their COO, and she was the point of contact for everything. Super organized, would be able to track stuff, move over and find advertising creative,
shameless
funnels.
plug, this is why you need a great COO.
And so that person's going to be the point of contact, the liaison, get all the stuff from all the people, and that's when counsel is going to start putting together the responses. And so after that response, and there could be many responses, right? I mean, you agree to a rolling production, or you're going to answer certain questions in a certain cadence because of whatever reason. After that is all complete, that's when kind of the advocacy component starts.
Okay.
I mean, you're advocating throughout the entire portion of it, but you're going to be submitting papers to the FTC explaining like, okay, you've asked for this, here's the information, this is why this is not an issue, or it is an issue, but this is what we've done to fix it, or something like that. So there's the kind of the investigation part that you're going to do with your counsel and then provide a written response. After that, that's when we start getting into trying to move it towards resolution.
Got it.
And that's going to depend a lot on what you find out in your internal investigation, how you respond to the FTC.
And what you've done on the front end to get there.
Exactly.
Best case scenario, what kind of time frame am I looking at dealing with this?
Lawyer answer, it depends. We've had some that have gone multiple years.
Wow.
Just because of how big it is. How many players are involved.
You get 60 supplements with 5 million claims over 2 years. Makes sense.
So I would say a 2-year process. Right? 2 years is a good, that's what I tell clients. We're in it for a bit.
Yeah. So probably don't get there.
Try not to.
Yeah. Wow. Scary stuff. I think every marketer is terrified of this. And just to kind of draw off of something that I've heard a lot in the industry is this is why I have all different companies for all my different products. I'll just shut down. That doesn't work in this situation, does it?
No, the FTC is not a traditional litigant.
Right.
I mean,
so explain that, because I don't think a lot of people understand this. I've heard this over and over again, and I've tried to eloquently verbalize what I know to be true, but because I don't have the vocabulary that you have and the vernacular you have, it doesn't ever work. So help me explain. Most people think that an LLC protects them, right? So I have an LLC, it's got a business, I get a CID, I shut down the business, what's the big deal? What can they do to me?
Well, it comes down to whether or not it's a common enterprise.
Mm-hmm.
And so, if these businesses are all working together in tandem, if there's someone at the top of it, if there's shared ownership, a board, all of that, the FTC is going to look at it and be like, this is all one big enterprise. You guys are all working together. I mean, sure, shut down that one LLC.
They'll find a way that you're piercing the corporate veil somewhere.
Yeah, you got 5 more LLCs and, a holding company up here. I mean, it's all working together, so the FTC is not really...
Okay, now let's say I only have this one company. This is all I have. Mm-hmm. I just shut it down. What's the big deal? Are they going to continue to come after me?
Absolutely. Well, in the biggest...
And they can come after me personally? That the LLC doesn't protect me?
No, and that's the biggest thing. The FTC, in recent years, probably the last 5 years, there's been a focus on putting owners on the order.
Right.
And it's not just the business anymore.
Right.
They're looking to put, if you run a business, you are going to be part of that consent order.
Right.
So, yeah, shut it down, but they're still coming after the owners.
I think it's an important thing to make sure that we explain to people, because in the wild, wild west days of direct response and e-commerce, it's churn and burn, right? Make a bunch of money, burn it down, start a new company, make a bunch of money, turn. And I personally haven't really gotten involved in those businesses, but we know a lot of people who do that. And that's just not a thing anymore, and I don't think a lot of people understand that.
Well, no, and that's why if you get a CID and you are the target of it and you've done something wrong, the CID is almost the better outcome of it all. Because it's not like the FTC is immediately going to court, filing a lawsuit, getting an asset freeze, and seizing a bunch of assets. They're actually coming to you first, and you're going to kind of walk through this investigation together. Mm-hmm. So if you know you've done something wrong, getting a CID is probably the
best case scenario.
Exactly.
Awesome.
So to just kind of net all this out, the CID is not the end of the world. It's not the end of your business. You will get through it. It's painful. It's
probably expensive,
but so long as you set expectations at the beginning, know that there is a future at the end of this. Get good counsel. Just put your head down and work through it.
Beautiful. If you've never heard of a CID, you're not ready for one. And if you've just got one, you're already behind. Ryan and I created for you a emergency kit that we hope you never have to use. This is going to be to help you navigate your first FTC request should you get one. Stay protected and stay smart. You can download that for free in the Visionary Vault at www.specialopspodcast.com. Compliance isn't optional, and silence is not your strategy. So follow us for more, like and subscribe, and see you next time.